The six-member Electoral Commission sworn in yesterday by Chief Justice of the Republic of Somaliland, Honorable Aadan Haji Ali, is invalid as per the Constitution and the Election Act of the Republic of Somaliland. The members were sworn in collectively, unlike the Constitution citation, which says they should be sworn in individually. The procedure followed was not the one stipulated by the Constitution. This is according to lawyer Beled Xaawo, a lawyer at Haqdon Law Firm.
The swearing of the members of the Electoral Commission, any new members of the Electoral Commission, is obliged by the law, the Electoral Law number 20/2001, and it is amendments. And the wording of the swearing, the oath they should take, and the procedures to be done are both mentioned in the law very clearly. What I have observed, and many lawyers observed from yesterday's swearing in, was that the process wasn't followed. First, the wording wasn't the one obliged by the law. Particularly Article 20, Paragraph 3 of the Electoral Law clearly stipulates the oath they should take and must take by every member of the National Electoral Commission. Secondly, they were not sworn on the manner obliged by Paragraph 4 of the same article, which says individually every member should take oath. But the way it was administered was collective. All of the 6 members were there and taking the oath, which wasn't the oath that was mentioned by the law. The question is there, does the authorities have the option to sideline the oath specified by the law? And the answer is no. They should take the oath mentioned and obliged by the law, which they didn't.
The lawyer has advised the Chief Justice of the Republic of Somaliland to do the oath again in order to validate the Electoral Commission.
The manner the oath was taken wasn't intentionally intended to be wrong. I think it was an error, and human beings are prone to make errors. Therefore, I think the people who did this, particularly the Chief Justice, should do it again. If you recognize the way you did something wasn't the way the law said, the option is to do it again. Because otherwise, they can't take over office, because taking over before members take office, they have to go through the oath. If they don't do that, they cannot take office. And if they take office without swearing in, it means that it's not legally valid. Therefore, I think it should be done again. Otherwise, the process will be very wrong. And already there is a dispute. Therefore, we don't need to have another layer of a legal dispute, very much related to a technicality of how something should be done.
Lawyer Beled Xaawo, who is also the former chairman of the Somaliland Human Rights Center, says the same happened in the U.S. during the swearing-in of President Barack Obama in 2009, when he was sworn in again a day after the initial swearing-in because he missed to follow the correct words in the Constitution, thus following the Constitution format plan, thus making following the constitutional format important.
It did happen in the U.S. in January 2009 when Barack Obama was elected to the office, and the Chief Justice of the United States of the U.S. has done it again. Obama repeated the actual and the correct wording of the oath, and to be clear, the one that was done by Barack Obama wasn't different from what he should do, but the wording wasn't following the same manner. Therefore, it should have been done, and that shows you how critical it is to have a correct format of the swearing. The words cannot be different from what is written in the law or in the Constitution. Even the structure and how they come should be the same way as it is in the law. That's why it should be done again.
Whether the advice of the attorney will be taken by the Chief Justice or not, it is clear that the new Somaliland Electoral Commissioners sworn in yesterday are invalid as per the Constitution. Yunus Deko, CBA News, Hargeysa.